After studying this module, you shall be able to identify the various methods of raising capital in a public and private company, to understand the meaning of prospectus, to identify various statutory requirements for a prospectus, to understand a misleading prospectus and various consequences and remedies available, to learn the meaning of abridged prospectus and shelf prospectus.
A public company may raise its capital by way of public offer, offer for sale, right issue, private placement. A public offer may be initial public offer or further or follow-up on public offer. It is the selling of securities by the company to the public in the primary market. It is essential for a public company to issue a prospectus if it intends to appeal to the public for capital to carry out the object for which it has been constituted. Prospectus is a document which gives all details about the company and the proposed issue of shares to enable informed decision by the intending investor of shares in that company. In offer for sale method, a company allots shares to issue houses or other intermediaries or promoters with a view to such shares being offered for sale to the public by such issue houses or the promoters. In certain situations, this offer for sale is deemed as a public offer by the company. Right issue is the offer for subscription of shares made by a company to its existing equity shareholders as a matter of their right. Private placement is issuing of shares privately to the friends, relatives, or acquaintances of the promoters.
Prospectus. According to Section 2, subsection 70, prospectus means any document described or issued as a prospectus and includes any notice, circular, advertisement, or other document inviting deposits from the public or inviting offers from the public for the subscription or purchase of any shares in or debentures of a body corporate. Thus, prospectus is a document inviting general public to subscribe to the share capital of a public company. Any document which has the object of securing the required capital or public deposits for a company comes within the definition of prospectus. Invitation to public. The term public includes any section of the public, howsoever selected. It connotes persons not personally known to the promoter as distinguished from his own friends, relatives, connections, and acquaintances. Even an offer to a limited class of people shall be an offer to public. We shall now consider the case of South of England Natural Gas and Petroleum Company Limited, 1911. 3,000 copies of document in the form of a prospectus were sent out and distributed among the members of certain gas companies only. It was held that though the offer was made only to a limited class, it was nevertheless an offer to the public, as those persons were nonetheless the public vis-à-vis the company, although they were not public at large, but a selected portion of it. It must, therefore, contain the particulars as required by the Act. In the following cases, however, the offer shall not be treated as made to the public. 1. If it is not made in a way so as to result directly or indirectly in the shares or debentures becoming available for subscription or purchase by persons other than those receiving the offer or invitation, provided the offer is made to less than 50 persons, section 42, subsection 2. 2. It is only a domestic concern of the persons making and receiving the offer or invitation, provided the offer is made to less than 50 persons and each offer is made separately to a particular addressee. Section 42, subsection 2. 3. If shares are offered to a few issue houses or qualified institutional investors, which have agreed to hold the sections as long-term investments. 4. If the shares are offered exclusively to the existing members with whom necessary information about the company and its issues is already available. 5. If the offer is made in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to the shares. Offer for sale or prospectus by implication. In this method, entire share capital of a company is allotted to an intermediary called issue house. The house then offers the shares to the public by means of an advertisement of its own, which cannot be taken as prospectus. We shall now study prospectus by implication. As per the provisions of Section 25, where a company allots or agrees to allot any securities of the company with a view to these being offered by the allottees for sale to the public, the document by which such an offer for sale to the public is made shall be taken as a prospectus by implication issued by the company if a. The allottee, issue house or other person, offers these shares or debentures to the public for sale within 6 months of the allotment, or b. At the date of offer to the public, the company has not received the whole consideration in respect of the shares or debentures. Thus, sale of shares through an issue house does not in any way reduce the liability of the company's directors, promoters, or other officers. On the other hand, in addition to them, the issue house incurs its own liabilities. We shall now discuss abridged prospectus. Abridged prospectus is memorandum containing such salient features of a prospectus as may be prescribed. Thus, it is a brief version of the salient features of a prospectus to cut the cost involved in the publication of a large number of prospectuses which have to accompany the application forms for shares or debentures in the case of a public offer. Section 33, subsection 1 provides that every application form for shares or debentures has to be accompanied with the abridged prospectus, provided that a full prospectus is to be made available to a person who asks for it before the closing of the subscription list. We shall now focus on the cases where the requirement of abridged prospectus does not apply. A. When the application form is issued in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to shares or debentures. B. In relation to shares or debentures which were not offered to the public. C. Where offer is made only to existing members of the company. Or D. The shares are uniform in all respects with shares already issued and quoted on a stock exchange.
Shelf prospectus. A company is required to issue a prospectus each time it accesses the capital market. It leads to unnecessary repetition for a company which makes more than one offer of securities in a year to mobilize fund from the public. A way out is shelf prospectus, which remains valid on the shelf for a specified period of time during which offers for securities may be made by a company to the public without going through the arduous exercise of issuing fresh prospectus every time. The Companies Amendment Act 2000 inserted Section 60A to enable public financial institutions, public sector banks, and scheduled banks, whose main object is to make loans to or subscribe for securities of private industrial enterprises engaged in infrastructure financing. Shelf prospectus means a prospectus issued by any financial institution or bank for one or more issues of the securities or class of securities specified in that prospectus.
A contract of shares in a company is a uberrime fide contract. The intending purchasers of shares are entitled to true and correct disclosures of all the facts in the prospectus. Neither any information which the law requires to be disclosed to the public be concealed or omitted to be stated from the prospectus, nor the information given should be false or misleading. A prospectus must make all statements with scrupulous accuracy and not state facts which are not strictly correct. A statement may be false not only because of what it states, but also because of what it conceals, omits, or implies. Suppression of facts will be as bad as disclosure of wrong facts. Truth, whole truth, and nothing but truth must be disclosed. Half truth is no better than a downright falsehood. Remedies against misleading prospectus. If a prospectus contains misleading or false statement or omits to disclose a material fact which amounts to misrepresentation, the aggrieved shareholder has the remedies: A. Against the directors and other persons responsible for the issue of the prospectus, and B. Against the company. Liabilities of directors, promoters, etc. The persons liable in case of the issue of the prospectus containing false or misleading statements are every person who is a director of the company at the time of the issue of the prospectus, every person who has authorized himself to be named and is named in the prospectus either as a director or as having agreed to become a director either immediately or after an interval of time, every person who is a promoter of the company, and every person who has authorized the issue of the prospectus. The liability of the directors, promoters, and others falls under the following heads: 1. Civil liability; 2. Criminal liability; 3. Liability under the general law of contracts.
Civil liability. Under Section 35 of the Companies Act 1956, every director or promoter or any other person responsible for the issue of prospectus containing false information shall be liable to compensate all those who subscribe for shares on the faith of the prospectus for any loss sustained by them by reason of any untrue statement contained in the prospectus. Subscribers to the shares are not required to prove fraud or intend to deceive. Liability arises whether untrue statement is made knowingly without belief in its truth or innocently by an honest man. The measure of damages or compensation will be the loss actually suffered by reason of the false statement in the prospectus upon which he had relied for the purchase of shares. That is, the difference between the value the shares would have had if the company had possessed the advantage stated in the prospectus not exceeding the price paid for the shares and their true value at the time of allotment in the circumstances which in fact existed. 2. Criminal liability. According to Section 34 of the Companies Act 1956, a person responsible for the issue of prospectus containing untrue statements of material facts after may also be held criminally liable under Section 447 of the Act. Number 3. Liability under general law. Persons responsible for the issue of prospectus can also be held liable in an action for deceit under general law as provided by Section 19 of Indian Contract Act. This remedy shall be available even where the remedy by way of recession as against the company is lost either through laches or negligence or even if the company goes into liquidation. But the plaintiff will have to prove it if A. There was a fraudulent misstatement. A fraud is said to have been committed if a false representation is made knowingly or without belief in its truth or recklessly, whether it be true or false. From this, it shows that there is no fraud if the person making a false statement honestly believes it to be a true one. B. Representation related to some existing material facts. Material facts mean facts which are important for the contract. C. He had seen the prospectus and is the original allottee. A person who had not purchased the shares on the basis of the prospectus, which contained false and misleading statements, shall not be entitled to any remedy, either that of rescinding the contract or that of claiming the damages. The leading case that can be cited here is Peake versus Gurney. Gurney issued a fraudulent prospectus on behalf of the company. No shares were purchased by Peake at that time. Several months afterwards, Peake purchased 2,000 shares of the company from stock exchange. He brought an action against the directors for deceit. It was held that the directors were not liable. D. He has been actually deceived. There can be no action unless the shareholder has actually been deceived. A deceit which does not deceive is no fraud. Besides, mere misleading of a prospectus cannot form the basis of an action for deceit.
Liability of the company. The shareholder who has purchased shares on the basis of a misleading or false prospectus has two rights against the company under general law of contract: A. Right of rescission. B. Right of action for damages. Right of rescission. A person who has purchased shares from the company on the basis of the prospectus containing untrue and misleading statement of material facts is entitled under the general law to apply to the court for the rescission of the contract. The agreement to take up shares is voidable at the option of the subscriber to the shares. It will remain valid unless he actually rescinds it. If the court accepts his application for the repudiation of the contract, the company will remove his name from the register of members and return his money with interest and other incident costs. Right to claim damages from the company or to rescind allotment of shares will not be available to the subsequent purchasers of shares from the market. They cannot claim any relief unless the prospectus was issued to induce them to buy shares. A subscriber to the memorandum of association cannot also seek any relief, as the company cannot be considered to be in existence at the time when he appended his signatures to the memorandum of association. He cannot be said to have been influenced by any statement in the prospectus. Right of action for damages. In cases where misstatement amounts to fraud, a grieved investor also gets a right of action for damages against the company. This right is available even after the company has gone into liquidation. In order to claim damages from the company, the claimant shall have to prove that A. The misrepresentation in the prospectus was made fraudulently. B. It related to a material fact and not a mere promise, forecast, or expression of opinion or expectation. C. He was a class of person who intended to act upon it, and that. D. He had actually acted upon it and suffered damages. A lottee cannot, however, both retain the shares and get damages against the company.
Prospectus is a document inviting general public to subscribe to the shares or other securities of a company. A prospectus to be valid must satisfy the obligation of SEBI, that is, issue of capital and disclosure requirements, and the Companies Act. A prospectus must make all statements with scrupulous accuracy and not state facts which are not wrong or not correct. If a prospectus contains misleading or false statement or omits to disclose a material fact which tantamounts to misrepresentation, the aggrieved shareholder has the remedies against the directors and other persons responsible for the issue of prospectus and against the company as well.